Near the end of 2010, Full Disclosure combined all of the hours of interviews completed with former U.S. prosecutor Richard Fine and wrote a script narrated by Edward Asner and readied the production for a feature documentary release. The one final scene needed was the reenactment of the intense moment in the courtroom where Dr. Fine accused Judge Yaffe of taking illegal payments from the LA County. Yaffe's response was to order Dr. Fine taken into custody to be held for an indefinite period of solitary coercive confinement. We petitioned the court to use that courtroom, Department 86, to video record a reading of that dramatic transcript in the very room where it occurred. After countless numbers of refusals, Full Disclosure sued the Los Angeles Superior Court. Federal Judge Manuel Riel of the California Central District summarily dismissed our case without a hearing. And so the public interest law firm Judicial Watch filed a petition with the Ninth Circuit Court of Appeals, requesting a hearing of our complaint. This Tuesday, the Ninth Circuit heard oral arguments in order to win our day in court. Paul Orphanides represented us in court. This is what they call a First Amendment case, isn't it?
Yep.
I know, being our attorney representing us, I would expect you to say that it's an important case, but could you explain why it's an important case?
Well, it's important because it's one of your cases, first of all, of course, but it's also important because there are some fundamental First Amendment principles that we're trying to establish.
The First Amendment principle in this case includes how government controls access to public buildings.
When they make this available, the First Amendment protections kick in. They can't arbitrarily make decisions about who can have access to it and who can't have access. And more importantly, they can't discriminate against people on the basis of their viewpoints. So the court, you asked 6 times, I believe, and you were told no 5 times, and the other time they just ignored you. So the court can't act arbitrarily in this kind of fashion. So what we're trying to do is to establish that this principle applies across the board. It applies to schools. It applies to courts even. So it's important in that regard. And also, just any time you try to stand up and enforce the First Amendment, it's an important case.
We asserted that as the media, we should be able to use the courtroom to complete our documentary. Mr. Orphanides claimed the First Amendment goes even farther.
When anyone wants to make use of one of these limited public fora is what they're called, the different protections of the First Amendment, the Constitution, kick in. So it's not just a freedom of the press issue, it's a freedom of speech issue, it's a freedom of religion issue. There was an important freedom of religion issue case that we relied on quite a bit in our arguments, in which a school district was making its classrooms available to the public after hours. And some group of parents wanted to show a Focus on the Family, Dr. James Dobson video series in the classrooms after hours. The school district said, no, that's religious. We can't allow that. The Supreme Court said, yes, you have to allow it. That you can't, the school district can't discriminate on the basis of what someone is trying to do, how they're trying to make use of these public spaces. Once the door's been opened to their use, you can't discriminate against people on First Amendment grounds, freedom of religion grounds, media grounds. So it applies a lot more broadly than just to the media.
What was it that they were so upset about not having us in that courtroom? What did they put in their reply brief, and what was the thrust of their main argument?
It's even hard to conceptualize what some of them are, because I think some of them were just really gross misstatements of what it was you wanted to do in the courtroom. They talked about, they mischaracterized your wanting to have some witnesses who were present at the hearings from 2009 that you're interested in, that your documentary is about. you wanted to interview them and have them read from a transcript. We're talking about using the courtroom as a sound stage and having actors come in and doing historic reenactments. I mean, it's this hyperbolic, exaggerated language that really had nothing to do with your very modest request, really. I mean, they were objecting, saying, you want to turn this courtroom into a sound stage, and that's just not allowed. That was bunk.
Well,
so they made a factual argument that wasn't incorrect. Then they also started introducing all sorts of facts that weren't before the court yet. They were trying to argue that what you were doing was covering a case that was out of time, that had already finished, as opposed to what CNN had done. They were allowed in when the case was ongoing, and they were trying to make some sort of factual distinction.
as you will hear in the following audio clip, the judges disagreed with the court's attorney. The first voice you will hear is the court's attorney, and the second voice is Justice Bia responding rather adamantly.
There's coverage of an ongoing case. It's news. Mr. Fine was still in jail.
Well,
So it's an ongoing case, and the complaint distinguishes between those two things, between coverage of an ongoing case where the guy is still in jail on the one hand, and the desire years later, after the guy's out of jail, there's no pending case, there's no appeal, there's no nothing, we want to go back and reenact, use it as a soundstage.
Aren't you making the decision of what is newsworthy for the First Amendment right?
I don't think so, Your Honor. What
You're saying it was, if Fine's still in jail, CNN can come in and use the courtroom. But Fine's not in jail, so it's not news anymore. It's a soundstage. We're not going to allow it. Who's making that decision?
The court made the decision based on...
Well, your people are making the decision of what's newsworthy or not.
so but basically he pointed out that the Superior Court is not in a position to decide what is newsworthy or not.
That's right. That's right.
So,
And one of the things that's just so lacking here is the Superior Court has had this practice of allowing people to come in and use their courtrooms after hours for a long time, but there aren't any regulations. There's nothing that guides how the people who make the decisions, who's going to be let in, who's going to be excluded. There's nothing that guides their discretion on how or guides their decision on how they're supposed to make that. And that's why the lawyer for the Superior Court was just throwing up all these facts that had nothing to do with anything, to our knowledge, and trying to see what sticks.
so the Superior Court hired the law firm of Jones Day to defend their stubborn refusal to grant us access. How much do you think this could amount to by the time we finish our battle to get our First Amendment rights?
I don't know what rates Jones Day charges the court or the state for its services. My guess is it's between, there's a couple different lawyers working on the case. Based on experience, those rates differ. The more experienced lawyers are probably, $500 an hour or more. Our hearing this morning, counsel for the court arrived around 8:30 and left around 11:30, so that's 3 hours right there. They do is do the math. I don't know if they get paid for travel costs or travel time, but it's certainly tens of thousands of dollars just to defend this. You'd ask for a half hour worth of time in the courtroom. It just doesn't make sense from a taxpayer standpoint.
Yeah, they had to defend themselves since we filed an appeal, right? They couldn't just walk away from it.
You could always try to resolve a case, between the parties. There's no reason why they couldn't have tried. I mean, what you've asked for is simple and straightforward. If they want to propose something in the alternative, that's fine. You can always try, short of spending, tens of thousands of dollars on lawyers and tying up the federal courts.
So why won't the Superior Court offer to settle with full disclosure? All we are asking for is a half hour in the courtroom.
There's really been no discussions in that regard because the court has been so adamant that no, you're not coming in. But it's just their own intransigence. There's nothing that stops them from trying to reach some sort of accommodation with you.
Wow.
I can't figure out why they are so resistant to this. It doesn't make sense to me. They have their institutional interests they're going to protect just like any other government, office or bureaucracy, however you want to characterize it. And for whatever reason, they've chosen to draw a line in the sand here, and it's with you.
Oh,
And
wow.
that half hour worth of time you wanted in Department 86.
Wow.
Can't explain why it's so important to them.
Our documentary, The Cost of Courage and Court Corruption, highlights the unreasonable attack by the Superior Court on Richard Fine, who documented and accused the judges of taking illegal double payments from both the state and the county. Is it because of what we were covering? The judicial double payments? Do you think they're sensitive about that?
It could very well be that there's a sensitivity there. There could be any number of reasons why they're doing what they're doing. And I don't know why they're doing what they're doing, and they didn't tell us. And that's part of the reason for the lawsuit is the lack of transparency in the process. They wouldn't tell us why they did what they did. So therefore, one of the conclusions we are left with is that they did it for an improper reason, or they didn't. There's no reasonable reason for why they did what they did.
We have almost finished the documentary, but it needs this critical climactic courtroom scene. The authenticity of using the exact courtroom where it took place is essential to the credibility of the production. Full disclosure has now become a part of the story, and it's important that as the news behind the news that we keep the public informed of the flagrant abuses in our justice system. We hope that you will help us in our fight by informing others who are struggling with the court system. And we need to raise funds to finish and distribute this production. As a 501c3 tax-exempt organization, your donation will help us to distribute this most important documentary and to restore the integrity of our justice system. Please, if you'd like to make a contribution, please call me at 310-822-4449. I'm Leslie Dutton. Thank you. You can listen to the Ninth Circuit Court of Appeals oral argument. It was riveting and a spirited discussion. You can hear the whole 30 minutes from a link below.